Zameer sir, I think we are good to begin now. Aditi, I request you to begin the introductions and then Mr. Nathani can take over. Thank you so much.
Thank you.
Good morning, dear panelists, the audience, and the organizing team. It is my pleasure to welcome everyone to our expert panel discussion on CCI Antitrust in Sports, an interplay between competition law and sports law. I take this opportunity to introduce everyone with the organizers, Lex Witness and Society of Corporate Legal Experts. Lex Witness is India's first magazine on legal and corporate affairs for over 10 years since its inception in 2009. As a monthly magazine, Lex Witness has become India's most credible platform for the legal luminaries to opine, comment, and share their views. Society of Corporate Legal Experts is an organization that aims to bring the fraternity members worldwide and the students of law and commercial disciplines to come together for sharing their thoughts on the commercial laws, policies, and current trends in these laws. I introduce everyone with our esteemed moderator, Mr. Zameer Nathani. Mr. Nathani is an LLB LLM in Civil, Corporate, Criminal, Customs, International Laws, UN, WTO. He's PhD from Harvard Business School, Executive MBA from Narsi Munji Institute of Management Studies, US IP Laws from Stanford University, Intellectual Property Rights and Area Certifications from WIPO, United Nations, Private Equity from London Business School, and M&A from Harvard Business School. Mr. Nathani was a law firm attorney for renowned and global corporates such as Eureka Forbes, LG Electronics, TCL India, Motul Oils, Ginger Hotels, Kale Consultant Softwares, Johnson & Johnson, and other MNCs from US, UK, and Asia Pacific. He was Associate Vice President for Reliance Entertainment, Digital Business, Global Gamings, OTT, and E-Commerce. Head Legal for Balaji Telefilms, India's #1 TV show company and OTT, and Director Legal for Raymond Limited, world's largest producer of worsted suiting fabrics. He's presently Senior Vice President and General Counsel for UFO Movies India Limited, India's pioneering and disruptive technology developer for digital format of all movies and other content for movie theaters and new OTT and UGC platforms. Mr. Nathani is a recipient of the prestigious Harvard Business School Alumni Challenge Award from Harvard Business School, Alumni Achievement Award from Narsi Munji Institute of Management Studies. In addition to other renowned awards, in the past, he is also recipient of the General Counsel of the Year Award from Indian National Bar Association at the gracious hands of Justice Sri Krishna, ex-Judge, Supreme Court of India, and Chairman of the Committee on Data Protection Laws. I now request Mr. Nathani to take it forward from here. I also request all the attendees to take care of certain rules. Attendees may please place all their question and answers in the Q&A box on their screens placed at the right corner. We will try and conduct a live Q&A session towards the end of the session. You may use the raise hand icon if you are interested in asking any questions live. In the interest of time and more questions, we'll prefer questions coming from the Q&A box. Please have a look at your chat box where the webinar help desk will be posting updates regularly. I now request Mr. Nathani to take it forward from here.
Hi, good morning, everyone. I think it's really a pleasure. Apart my introduction, we have equivalent stalwarts and more than that for you today. The subject of our discussion today is CCI Antitrust in Sports. This is one of the fundamental subjects when I discuss with you what is the agenda of the day. First, I really want to compliment Lex Witness, one of the biggest legal event organizers, very well known in the fraternity for organizing legal events. And it's also India's the first magazine on legal and corporate affairs, and Society of Corporate Legal Experts for organizing this very important topic, much known in the legal circle, not discussed much, but having a great impact, because when you talk about sports and antitrust, it goes to a different level where you are living in the world of IPL and everything. So this is one of the hottest and the best subject of discussion. We have some cases like Surinder Barmi versus BCCI. We had Hemant Sharma and All India Chess Federation. We had Dhanraj Pillay, very well-known figure in hockey, versus Hockey India. We had Shravan Yadav versus Volleyball Federation of India. We had DLF City Club members, Welfare Association versus DLF. It's about anti-competitive agreements. It's about the abuse of dominance position is the subject matter of discussion today. And we are so fortunate today to have great members, panel members who are rich in experience, they are acclaimed, they are achieved in their field, that their views will really matters and the discussions will really go to a next level. I want to first introduce my panel members. We have Mr. G.R. Bhatia. Mr. G.R. Bhatia, very well known in the fraternity, is also ex-Director General of Competition Commission of India. He is presently partner and head of competition law in Luthra and Luthra. He has practiced in antitrust and competition related areas and has varied experience of representing clients in CCI, NCLET, High Court, Supreme Court of India. He has been consistently ranked also among the leading antitrust lawyers by Chambers and Partners from 2012 to 2019. He has actually recently also qualified with the independent direct examination. Apart that, he has been also a registrar of companies. He has also served in Jammu and Kashmir as well as Patna High Court as official liquidator. He's also been on the editorial board of Chartered Secretary, which is by Institute of Company Secretary. Welcome, Mr. Bhatia. It's a privilege and honor to have you as one of the distinguished learned person in the fraternity and today at this panel. My second speaker is Mr. Pulin Kumar. We are very fortunate to have him, one of the senior most legal members in the corporate fraternity, legal fraternity. He's Senior Director Legal for Adidas India, very well-known figure in the legal fraternity, very well-known for his views. And it really makes a difference because, you know, these are all the views which have now culminated into a law because of the experience and the cases which have been dealt under his belt. My next speaker is Mr. Satwik Shaker. Satwik is presently the legal consultant at the Center for Trade and Investment Law, which is part of Government of India. It was originated from Ministry of Commerce. It's part of Government of India. In his capacity, Satwik provides legal assistance to the Government of India in international trade and policy. Satwik's current areas of focus includes WTO law, trade regulation, electronic commerce, and international investment law. He has been involved in multiple international and domestic policy formulations for the Government of India. In fact, just to bring to the notice of my audience, Satwik also contributed to India's FTA negotiations with EAEU, Peru, Mauritius, and most notably, he was part of the Indian delegation during the RCEP negotiations. He has played a key role in preparing India's draft e-commerce policy. He was previously associated as was an associate in general corporate with the Delhi office of Cyril Amachan Mangaldas before taking up the position of research fellow at the Center for WTO Studies. He has also served in the editorial board of Journal of International Trade. Welcome, Satwik. My next panelist is on the forum is Niti Richhariya. Niti has been an associate presently. She's joining as competition law in the competition law team for Shardul Amarchal Mangaldas. However, the great experience she also brings because she has been a research associate with Competition Commission of India. My other speaker is Mr. Abhishek Malhotra, founding and managing partner of TMT Law. Abhishek has been known in the fraternity, technology, media, wherever you go, or if there is a DOT matter, if there is a TRI matter, Abhishek's name is very prominently there because some of the policies and some of the regulations which have been brought into force, some representations and many things have been also done at the TMT Law. very well known in the fraternity, Mr. Abhishek Malhotra. I welcome him. My next speaker is Aahna Mehrotra, again, partner at TMT Law. And going forward, the discussions which we will have, Mr. Bhatia is there with us as one of the senior most person in the fraternity in this field, Mr. Kumar, Mr. Abhishek Malhotra, Mr. Satwik Shaker, Ms. Niti Richhariya, and Ms. Aahna Mehrotra. These are all the star-studded panel we have got for you to discuss today on CCI, Antitrust in Sports, covering the agenda we have already provided to you. On the sports issue, on abuse of dominance, or where there are some anti-competitive agreements and their views on those matters. With this, I would first like to bring to the notice of my audience that since Mr. Bhatia was so experienced and he's also been an ex-additional Director General of CCI, we thought that we should have some introduction from him on the subject of CCI, because he has been on both phases when we had one MRTP Act, which is Monopoly and Restrictive Trade Practices Law. He has been associated with the regulatory body since that time. And then we had CCI, Competition Commission of India, or the Competition Act, which came into force. So he has been into both regime, and we wanted him to give us some 5-8 minutes introduction on the scenario, and then move towards the subject of asking him the first question itself on BCCI, the matter of BCCI of 2013. With that, I open up the panel for my panelists, and I invite Mr. Bhatia to give the introduction to my audience. Thank you very much, everyone. You're
Mr.
on
Bhatia,
mute.
could you please unmute yourself, please? Thank you.
Thank you.
Audible?
Thank you, sir. Yes,
Okay.
yes, sir. You're audible. Thank you.
So thank you very much, Lex Witness and Society of Corporate Legal Experts, for organizing a talk on antitrust issues in sports. It's very relevant for sport, all those who are associated with sports, and also equally important for those who are engaged in rendering professional services to sports people. I will devote, I think, 5 to 7 minutes on what the competition law is. Has it achieved its objective purpose, and how relevant it has become in our day-to-day life? In fact, day in, day out, we speak we move from the bed, we talk of competition. It is increasingly now recognized more than ever before that competition in markets is benign for everyone, be it consumer, be it industry, be it businesses, be it economy as a whole. According to OECD, it is competition which brings prosperity. And you will notice that in all sectors where competition is lacking, you will find inefficiency, no lack of innovation, and absolutely no growth. So we do need competition in all walks of life. And friends, you will astonish. I will give you simple example, like the moment the family is blessed with a second child, the first child starts getting the heat of competition. In terms of sharing of love and affection of parents, grandparents, and other relatives. So imagine who is, this new child is a new entry. It is just like in recently, about 3 years back, you have noticed that Reliance entered this mobile market, and the existing incumbent player, Airtel and Vodafone and Idea, they were shaken. So the moment a new member in the family arrives, the landscape of competition, even within family, gets disturbed. So competition has become a hallmark of growth. And the two latest example which I would like to give you is, sir, COVID vaccine. Imagine, friends, all of you know, day in, day out, both in print and electronic media, you are listening news about COVID vaccine efficacy, side effects, pricing, availability, distribution model, how many doses, whether shots should be given to those who are already affected with COVID and recouped it, or to an person who has not been affected at all. So all these issues, how important they are for us. And so each one, whether it is Pfizer, whether it is AstraZeneca, whether it is Serum Institute or any other, or Moderna, all are fighting for a place in the market. Who will be the first? Even that is also an issue which is highly being debated. And equally important is the role of regulator. Which authority will give approval first? So we will be the beneficiary of competition, and we will have efficient, effective medicine at the most affordable price if we can ensure that there has been free and fair competition in the availability of COVID vaccine. The other issues which every day we are reading in the news media is about the farmers issue. They are on agitation, and completely it is a competition issue. The government want to do away with the purchase monopoly of state-run mandis. They want to allow that larger stocks can be stored by the private parties in the godowns and in the cold storage. And similarly, they want to foster and promote contract farming, etc. On the other hand, the farmers, they are not confident, that they want assured income, assured money, and they don't have confidence. So here what is lacking is that, are they confident that the competition regulator will be able to ensure that those who have been authorized to buy their stocks and farm output, whether they will be able to give fair treatment to the farmers, to the producers? So here comes the role of a competition commission. So competition commission has to come up to that level so that general masses, people can have confidence that here is a regulator who will ensure that innocent will be given protection, and those who are violating the law, stern action will be taken against them. So all this agitation is once again a competition issue, sir. So, but having said all those things, sir, let me tell you, competition has got 3 unique features. I am talking of competition. I practice competition, but I don't want competition. It's a human nature. No one wants competition in the area where he is doing his business or job. I don't want that there should be another antitrust lawyer in Luthra and Luthra, because if there is another equally efficient antitrust lawyer, that will make Mr. Luthra far more comfortable. So but at the same time, kindly appreciate that if there is a pressure of competition on me, certainly I have to continuously pull up my socks. And you know what is the fault of Guru Dronacharya is that he asked Eklavya to give essential facility of this Dhanush Dhari because he killed a competitor to Arjuna. And with the death of Eklavya's issue, you see, the Guru has not performed a role of a model Guru. And that's why we don't worship Guru Dronacharya, though he has been a very able teacher. So once Eklavya has gone out of the market, that means there is no pressure of competition on Arjuna. And so there was no necessity for Arjuna to hone his skills on a regular basis. So having said all these things, sir, competition has become extremely important, and so is the case in sports. And unfortunately, in the sports, all sports organizations, they have got dual role as an organizer of games, and at the same time, they are vested with certain rights which they sell to the people associated with that game. And here comes the question that while exercising those rights, should they abuse their dominance? Should they do arbitrariness while in their conduct? So here are few issues relating to sports business. But let me tell you, sir, that absolutely there is no exemption. There is no escape valve for sports people, and they are equally subject to the discipline of competition law as any other sector. Thank
Very
you.
well. Very well said, sir. And I think one of the blessings of Indian economy is that we have certain correlation examples which are there in the spirituality, which we also try to adopt. But that's been always the debate whether fair competition is really a fair competition. And number one, number two, how do we bridge fair competition and it crossing the line of it? And number three, where you have even intellectual property rights, where patents are granted exclusively for 20 years. How do you bridge that gap with the anti-competitive behavior? And of course, where you have sports contract, where you have various brands which are there, which are sponsoring IPL, which are sponsoring events, and they want exclusivity. How do they achieve their marketing target versus how do they behave in the fair market? Has always remained a subject of discussion. Very importantly, I can ask you one question. You have been a regulator, you can be critical with diplomacy. And therefore, I would like to ask this first question to you, Mr. Bhatia. We had a CCI order in 2013, which imposed a penalty of 52 crores on Board of Cricket Control of India, BCCI, for abuse of dominance. Post this matter was remanded to Compact, the CCI, post remand by Compact, the CCI reheard the matter, and for same abuses, the CCI in its order of 2017 again imposed a penalty of 52 crores. Are there justifications for imposing the same amount of penalty, or could have been looked in a different way? Mr. Bhatia, your views.
Yes, it's moderator, sir. It's really a very interesting question. That the matter has been the CCI. The first order was passed in February 2012, and the subsequent order has been passed in November 2017. The Compact remanded the matter because Compact was convinced that the principles of natural justice have not been adhered, and the charged party was not shared with the allegations as eloquently as should have been. Having said that, so Commission was asked to look afresh. So for the learned panelists and for the attendees, let me tell you, sir, that the intent of remand is that let new eyes look at the same matter. No doubt facts remain the same. New set of members and chairperson looked at in 2017, and they still decided to impose the same penalty despite host of, you see, variations. One, that in the 2012 order, the relevant turnover, the turnover which they took into account was the total turnover of BCCI for the years 2007, 8, 9, and 9, 10. And the penalty was imposed at the rate of 6%. In 2017, different set of people, they took into account relevant turnover which was generated out of IPL business. So only IPL revenue was taken into account, and the years involved was 2013, 2014-15 and 2015-16. And the initial penalty was at 6%. The subsequent penalty was at the rate of 4.48%. Why change in the rate when facts have not undergone change? Why is so here in this? If you kindly see 2017 order, Commission first decided that the penalty will be this much, and then they said this will work out to be 4.48%. While in all other cases so far, Commission first decides that we will impose penalty at the rate of 4%, 5%, or 6%, or 7%. In this case, they said no, they decided first the quantum of penalty, and then they said it will work out to be 4.48%. Not very happy decision as I am, but I would refrain myself for commenting further because the matter is right now in appeal.
I agree with you, but good opinion, good perspective on the regulator when the matter comes for adjudication. We normally try to see our side of the coin and never sit on that side of the coin, because the regulator also has to see the whole perspective, and therefore it's both sides of the coin, and you have given that perspective to us. While we keep on focusing on the regulator, I want to go to Pulinji. Number one, I want to really thank him because he is outside the place and has still come up for this particular thing. Pulinji, we are grateful to you that you are able to join and you are be with us. You're a very senior and very experienced person. While we were focusing right now on the regulator, without putting you into any tough situation, just from a perspective, because this is an intellectual debate we are having on the positions of the exclusive agreements, are the governing bodies of each sport misusing their dominant position to their advantage by way of an exclusive agreements? And do they even fall under the ambit of competition law provisions? Pulinji, welcome again. Thank you very much.
Thank you, Zameer. Thank you so much. And thank you, Lex Witness team. I'm delighted to be here, although I had to do a little bit of, I had to drive a little bit, to come under the Wi-Fi connections, network connection somehow. So thankfully, I am in time. I hope I am not delayed.
Today, we are more dominated by the technology than we used to dominate.
Yeah, so, and I'm equally delighted to share the dais with the stalwart like Mr. G.R. Bhatia. We have been, in touch for quite some time. And again, good to see some young faces, Niti, Aahna, Satwik, and last but not the least, a very good old friend, Abhishek. We have been, in touch. We have been sharing many, sorry for the disturbance, please bear with me because I am in a different place, so this will keep on happening. so yeah, I was on Abhishek, and we have been, we have been sharing many diocese earlier also together, and we have been in touch, and he has been doing a tremendous job in his field. So quite happy to be here.
Thank you.
Coming to the point of the dominating position of the sports body or the my point of view is slightly different. Yes, of course, if you talk about in any sports, the CCI has of course played a role of umpiring, active umpiring, and now probably after deciding few cases like which we have seen in the past, like VFI case and some other cases. Now probably the set has been tone has been set, and the CCI becomes or plays more of the role of third umpire because things have been set into perspective, and then people should follow it. Yes, from the perspective of dominating position, I would say, I have a little bit different view here because, if you talk about Volleyball Federation, who was the direct beneficiary of the whatever contract, if you look at their position, kind of investment, kind of fee which they have to pay is humongous. I mean, if you talk about BCCI, and I would just passingly mention here in the recently, the biggest partner of BCCI has exited now, who has been for more than 8 years, I believe. And they had, invited recently before this IPL, which has happened in UAE, for bidding. And you will be, I don't know, we will be surprised to know there was no bidder for BCCI sponsorship. While Nike exists, from the sponsorship, there was no actually, I mean, they didn't get any good sponsorship. I mean, who could, although there has been division of the sponsor, like, 3 or 4 categories have been made. So my point is that, if a sponsor or a partner invests a lot of money, then as it goes on the equal pedestal of if it is a patent creation, then he gets some protection and he has some right to create wealth. So why not the sponsors or kind of, the partners who are coming into the net or partnering with the sports body, they should also be given some, kind of leverage. Otherwise, as it happens, you see the results are before me. No bidders will be available tomorrow. So therefore, commercialization of the sports is of course there. I mean, the commercialization in every aspect is happening nowadays. So unless until there is a partnership between the corporates and the sports body, of course that partnership has to be on a very healthy ground, healthy sort of relationship, where no law is violated, no competition is impaired in that sense. So therefore, my only point is that yes, there has to be some balancing, and rightly, umpiring has already been done. Now it's a matter of third umpiring by the regulators, so that the people act properly and they consider everything in an appropriate manner. So to begin with, I'll just put my this thought, and yeah, over to Zameer.
Thank you. No, I agree. I think the example of which you recently gave, that there were no bidders, and the other example of a corporation which you gave, I think really makes a difference, where it has to be. That's why we always keep on speaking when we talk about competition law, is the regulator also speaks about it, is how do we balance it? Because at point of time when you increase these things, whether to introduce a fair competition, whether you are killing competition or the industry itself, is one of the questions which always gets debated and questioned. Regulator has its view that, these are representations which are made by parties, but whether these are interested parties or whether these are fair parties is also a question. On the side of the industry, you also come out with a reasoning saying that, too much regulation is not good for the competition, let alone competition not good for the industry. And therefore, it may affect, and at point of time, we may become incompetitive, not only locally, but also internationally, if there are too many regulations. I think that debate keeps on continuing. But otherwise, the regulator has played its role. Inquiries have been conducted, and I have also seen at some point of time, maybe there are many judgments which have been challenged there up to Supreme Court. But I think regulator makes it a point to inquire into the matter. Going forward on further steps of adjudicating the matter will always remain a question of arguments and debates, etc., and itself the adjudication itself mechanism. But there is always a room for improvement. Satwik, coming from your point of view, you are being associated with International Trade and Finance, which is a wing started by Ministry of Commerce. You represent the government of India. I want to ask you a questions from a regulator point of view. Has CCI, while determining the question of abuse of dominance exercised by the governing bodies, given a clear situation on a subject matter, or has it created an ambiguity in the position by giving just opposing decisions in similar matters? Your views.
Thank you, Mr. Nathani, and thank you, Lex Witness and SCLE, for inviting me. The question is a very relevant question, because right now, when we talk about competitions in sports sector, the jurisprudence is very limited, and the CCI has had like maybe a handful of cases to deal with. The Volleyball Federation of India case, as Mr. Pulin mentioned, the Chess Federation of India, BCCI. So the question is, when you are talking about abuse of dominance, we all know that dominance is not a problem, abuse of dominance is a problem. Now, having said that, I'll very briefly like to inform the attendees what really the CCI held in two similar cases. One with respect to BCCI, where BCCI tried to use the provisions of the media rights agreement to stop competitive private leagues which would be a competition to IPL. Like we all remember that Indian Cricket League used to be organized privately for 2 years, and then it abruptly stopped because BCCI imposed certain restrictions on.
This is ICL and IPL.
Yes, ICL and IPL. BCCI was backing IPL and did not want ICL to be promoted, and it stopped. It used the provisions in the IPL media rights agreements to not organize, not recognize, and not even support any privately organized T20 league in India. Now that was challenged, and CCI held that yes, BCCI is in a position of dominance, and through such provisions, BCCI is abusing that dominance in order to exclude or prevent any competitive league from entering the market, which will be a competition to IPL. So that's the first case. The second case is Dhanraj Pillay versus Hockey India. Now this is a very interesting part because this case just follows the dissolving of India Hockey Federation, and India Hockey Federation used to organize Premier Hockey League, and Premier Hockey League was doing really well for 5 years, and then due to internal politics and other issues which remained under the blankets for quite a while, Hockey India as a regulator and as an organizer emerged, and they wanted to revamp the league and introduce Hockey India League. Now in doing that, Hockey India also did somewhat adopted a somewhat same approach which BCCI did. In Hockey India's code of conduct for players, it imposed restrictions on players participating in any prospective private league, which could be a rival league to Hockey India League. And it was held. The BCCI actually acknowledged the fact that there was dominance. BCCI acknowledged the fact that there was an undue restriction on movement of players between, like, if I'm a hockey player, I want to join a rival league and not HIL, the Hockey India League, I couldn't do that because there was a threat of me being blacklisted. Maybe I wouldn't get a chance to represent India in the Olympics or the Asian Games, or maybe Sultan Azim Shah Trophy. So as a player, I would really not want to join a rival league because it would tarnish my chances of representing India. So the issue is that a lot of people say that CCI, although it acknowledged the fact that there was dominance, CCI did not held that there was an abuse of dominance because probably there was no anti-competitive agreement, because in the BCCI's case there was the media rights agreement which was held to be anti-competitive or anti-competition. In Hockey India's case, there was no such agreement per se, and it was just a code of conduct document. And Hockey India also approached the FIH, the Federation, the international world governing body for hockey, from kind of blacklisting these players. Now, it's easy to say that when there are two cases of similar merits, if CCI held abuse in one case and in other case CCI holds that there is no abuse of dominance, it's easy to think that there's an ambiguity in the position, and CCI might be contradicting itself. But maybe let's try to look at it from CCI's point of view and see that, and acknowledge the fact that probably CCI is looking at it on a case-to-case basis on merits. And when you look at it from that point of view, maybe you could say that despite two diverging decisions on different grounds, CCI could be correct to hold BCCI accountable for violating competition law, but not Hockey India as much. But interestingly, there's a very interesting note that CCI actually, I mean, even if it did not find that there was abuse or dominance on Hockey India's part, CCI actually very clearly directed Hockey India that its regulatory powers are not used for influencing and deciding on matters relating to its commercial activities. So as we've discussed, that sports are not just about sports. There is a lot of revenue involved, a lot of investment involved. These are commercial arrangements in place there for broadcasting, for organizing, for hiring of stadia and hotels. There are a lot of commercial activities going around sports. So yes, I think I think we can't say that there's an ambiguity, but maybe CCI fell a couple of steps short by not holding Hockey India accountable as much as it did with BCCI, because CCI did very clearly mention that that Hockey India is a regulator, that's a sports governing body. In this case, Hockey India, it could be any sport. That even if you're a regulator, you must not use your regulatory powers to influence and decide the matters which are non-regulatory, rather which are commercial and sporting. So that brings a very important question: is what would be the relevant market in these cases? As a regulator, can we say that relevant market, if you're a regulator, your BCCI, your Hockey India, is your relevant market event organizing or sports competition organizing? There is no correct answer to this at this point of time, because in BCCI's case, the CCI said that organizing of private domestic cricket leagues was the relevant market, but BCCI said that no, that is way too specific. The relevant market should be it should be organizing of entertainment events. Now that brings a very important question here, which we've seen. It's not a competition question; it's a taxation question. We've had Formula One races in India, in the Indian Grand Prix in 2011, 12, 13 at the Buddh International Circuit in Greater Noida. It just happened. It just happened for 3 years, and then the contract was terminated. Why? Because for taxation purposes, Formula One was not regarded as a sporting event, but as an entertainment event by the UP government, and therefore it wanted to impose higher taxes. So keeping that confusion in mind, because whether this event is an entertainment event or a sporting event, that's very important. Unless we define that relevant market, it might be a little difficult and a little premature right now to say whether CCI there was ambiguity on CCI's part or not, because we just had 5 cases, I think 4 or 5 cases. We need more cases, and we need more diverse understanding of the matter to see whether we can hold. There can be a merger of regulatory powers of a body along with its commercial powers, or we can have a proper, well-decided straitjacket differentiation between the two. So that's my response to your question, Mr. Nathani.
No, I completely agree with you. I now understand why you've used the word juxtaposing, because there might be some contradiction, and whether those contradictions, like you gave an example of BCCI and hockey having a different kind of set of responses. But yeah, this has been in the news, and that is why I think we are having this grand conference, because sports has been in the forum of competition and antitrust focus, highlighted very much, not more in the news realm, but yeah, and when you speak about any event like IPL, when you speak about any big events, there are multiple commercial considerations which are involved. And I think that is why the regulator also looks with an eye on it. Aahna, I just want to take it forward from Satwik. If that be the case, why should, maybe controversial, non-controversial question, but I think we are here to debate intellectually on the law. Why should sports not be treated as any other business? And has the intersection between the EU law and Lex Sportiva being recognized to give room to sporting bodies to show how and why certain rules are necessary to accommodate their peculiar concerns of fair play, credible competition, national representative sides, etc.? Aahna, your views on that?
Thank you, Zameer, and thank you, Lex Witness, for having me. So I'm just going to take a step back and talk about sports law versus competition law, and try to cover the whole Lex Sportiva angle by quoting a couple of judgments. So it's basically this case called the Bossman Ruling, which sort of laid down the genesis of sports law, so to speak, in Europe. And starting from Bossman, which basically pertained to a footballer, a Belgian footballer who was at that point in time contracted with a club in Belgium. It was called the Royal Football Club de Liege. And his contract with that club was coming to an end, and they wanted to renew the contract. But they wanted to offer him a salary lower than his then existing salary. So they were offering about 500 euros at that point in time. For those of you who don't understand how the whole football player recruitment market works, I'll just explain that once in Europe, you're taken to be an employee of a club. That's not the case in India, but in Europe, you work as an employee of a club. So till such time as your current contract is in existence, you're technically not supposed to be negotiating a deal with another club. It's not as simple as today, I can approach, as a lawyer, I can approach another law firm, get hired, and then serve my notice period and move. So the current law that exists now, I can only begin negotiations when my contract is about to end, which is a period of 6 months remaining in my contract is when I can even consider talking to other clubs. That is what the current rule is. But back then, that was not the case. Any sort of footballer then contracted with the club was owed a transfer fee. And this person was not deemed to be a free agent, so to speak. So when the Belgian club offered Bossman renewal, he rejected that offer. And meanwhile, he was also in touch with a French club. Now, this French club offered him a much higher salary. It was about 2,500 euros that they were willing to offer him. And along with also some sort of a signing bonus ranging about 25,000 euros. Bossman then got in touch with his Belgian club, got the two clubs in touch with each other, the French and the Belgian club. And a deal was struck that the French club would pay the Belgian club a transfer fee of about 120,000 euros, if at all they were to hire him, or they would take the player on loan for about 30,000 euros. Now, this loaning concept is also pretty interesting that, it's like a sort of a secondment model that we use at law firms, that you place an associate in an office and that associate will work full-time for that particular office. So that's how, you can loan a player for a season and the player will then play that season for that particular club and fulfill all the obligations of that particular club. But in this case, everything is subject to an NOC being issued by your national sports federation. So the Belgian club was supposed to be applying to the Belgian Football Association to give an NOC to the French club, and that's when the player could get recruited by the French club. Now, the Belgian Football Club had some doubts with regard to the solvency of the French football club, and therefore eventually told the Belgian Football Association to not issue the NOC. Because the NOC was not issued, eventually Bossman couldn't get hired by the French club. And that is when Bossman approached the Belgian court, who then referred the matter to the Court of Justice of the European Union, who held that basically the European Community regulations on free movement of workers applied to the world of sport as well. And therefore, this was considered to be a restrictive practice. All right, a player who had reached the end of his contract with a particular club was a free agent and was free to sign a contract with another club without such new club actually paying a transfer fee to the old club if you have reached the end of the contract, right? In that case, also the Court of Justice acknowledged the fact that while this will, a player would, that this whole process of free transfer may restrict local hiring, so to speak. It will also open up the opportunities of getting hired throughout Europe for a particular player. All right, because this also had something to do with the second challenge that Bossman had made, which is basically that he had challenged the 3+2 rule that existed at that point in time, which was basically that not more than 3 foreign players could play for a particular club at that point in time. So it was 3 foreign players versus another 2 players who had actually played for a football association for 2 years, for 5 years could then play. So that was a 3+2 rule. Now, both these rules were sort of held against the, fair sort of movement of workers through Europe. And what the EC held was that while this restriction of even 3+2 was only done at a club level, and the clubs were bound to anyways release the players for their national football association, and these restrictions were not put in at a district or a state level, if I was to put it in an Indian context. Like if today, a club in England. So there are several clubs that exist in London for that matter. Chelsea could hire anybody across UK. It's not that Chelsea must pick up a resident of Chelsea, so to speak, to play for Chelsea. So it was not applicable at a district or a state level. It was only applicable from a nationalistic perspective. So what eventually Bossman did was that laid, seriousness of the citizens' rights in terms of the European concept. And what Bossman did was it also led to FIFA adopting new regulations with regard to the transfer market. Now, while this spoke about largely an employment issue, we moved on to the Mecca Medina case, which pertains to a doping issue, but specifically dealt with competition law in Europe. There were two, and the Court of Justice referred to the Bossman ruling in this case. What happened in this case was that there are two swimmers, Mecca Medina and Mekjan, who were banned from competing in swimming activities as swimmers for a period of 2 years, basis failing a doping test. Now, these two swimmers filed an appeal at the European Commission that they were being restricted to pursue their means of livelihood and earn a living because of this ban. What was contemplated, while obviously the European Commission excluded, rejected their appeal, and thereafter they filed an appeal with the European General Court, which also rejected their appeal. Now, what the European General Court did was that the grounds for rejection laid out by them were basically that this pertained to a purely sporting rule and sporting activity, and that had nothing to do with the commercial aspect, and therefore it was outside the scope of the European competition laws. That was not the case. That thereafter they appealed to the CJEU. Now, what the CJEU, while rejected their appeal, that yes, doping, so anti-doping measures were essential to the ethos of sport, but they also corrected the EGC finding, which is that the sporting rules can be entirely separated from the economic sort of factors. That is what the interesting thing is. So the CJU entertained the appeal to make a correction in the EGC finding, which was basically the EGC finding exposed the intellectual incapacity to the attempt to establish a separation between sporting rules and the rules of economic nature, right? So in this whole situation of Mecca Medina, what was established was that sporting rules, while enjoy their own peculiarity, they must also have an economic impact, and that is what must be looked into at all times, while also giving them sporting bodies the independence to sort of function independent of competition laws becoming overbearing on what it is. So therefore, I mean, today coming to a completely financial aspect of things, if I don't impose certain restrictions or good practices, one needs to understand that the whole ethos of sport economics is based on the unpredictability of the result. The moment people know the result, or the moment people know that matches are fixed, nobody's going to watch sport, and that whole economic advantage of sport is going to die out. I mean, even at the fact that today, to put it from a tech perspective, the closer the competition is between an Apple and Samsung, right, is not what is really going to benefit either company. Each company tries to move further away in terms of tech advancement to be able to sell an iPhone, or for that matter, the Samsung premium phone. But as far as sporting rivalry is concerned, right, the closer the competition, the better it is. I mean, today, when Manchester United is playing Manchester City, because of the rivalry that exists, or Real Madrid is playing another top club in the Spanish league, say, FC Barcelona for that matter, is when there is maximum viewership, is when there's maximum sponsorship, and there's maximum. So one needs to realize that sport in itself is a unique concept in terms of competition. And therefore, there must be a fair amount of independence given to sporting bodies, but also it cannot be entirely separated from other rules and regulations.
I agree. I think that is why CCI keeps stressing on the point that we are only trying to say what the Constitution said is reasonable restrictions. Maybe
Exactly.
CCI says it in a different language or the words. But that's how balancing it is. You gave example of sports and technology. I think the first argument which comes from these grounds is that we want a free market. But this free market concept, CCI gets into it and says that this free market is not only meant for you, it's meant for others. So maybe that's a bridging of the gap between CCI and the industry. But yeah, the regulator keeps an eye open because while all these discussions do happen, regulator wants to ensure that it's there in the certain reasonable restriction of it, so that everything looks to be fair and compliant. Going to Niti, one of the best part of asking you this question is you have recently been at Shadul Amarchal Mangaldas. You're going to join as an associate in the competition law team. But we are also fortunate that you were one of the research associate with the Competition Commission of India. And therefore, this is a question to you. What is the CCI's current take on treating the sports governing body under the Competition Act? Some ground reality, if you can also give it to us. Thank you.
Thank you so much, sir, for the question. And thank you, Lex Witness and SALE for inviting me for this great webinar. Before answering the question, I would like to say that the question of application of competition law in sports arena arises from the commercialized nature of the sport association bodies and the dual nature that these bodies have, one of being a regulator of the specific sport and second of organizing various events. First, before analyzing the specific facts of the case, CCI has to deal with the issue of jurisdiction in all these cases. And that's where we come to the question of CCI's take on these governing bodies. Whenever any sort of antitrust analysis question comes to CCI, first question it looks into is whether the body under consideration is an enterprise or not. And for determining the nature of it being an enterprise, CCI needs to look into the kind of function it discharges. Beginning with the BCCI case, when the judgment was delivered in 2013, CCI clarified its position, saying that it's the function of the body that will determine CCI's jurisdiction for any of these bodies instead of its actual constitutive nature. So though there may be a discussion whether BCCI is a state under Article 12 or not, however, so far as it is discharging any sort of economic activity, it will be amenable to CCI's jurisdiction. And this jurisprudential issue has again been settled by Honorable Supreme Court of India in Coordination Committee's case of 2017, wherein it reiterated and established the law that one needs to look into the functional approach instead of looking at the constitutive approach. Because this is the reason why various other government bodies such as GDA and DDA also become amenable to CCI's jurisdiction whenever there is a case relating to sale of flats to the buyers. They come up with the argument that they are a state entity and they are performing functions which are relatable to those of sovereign functions. However, CCI has time and again clarified that so far as your nature of activity is economic, you will be amenable to our jurisdiction. The nature of economic activity means that there has to be some sort of sale and purchase involved. There need not be any sort of profit angle. So if any of these bodies try to project the argument that we are not keeping any portion of the revenue to ourselves and we are just channelizing all of it for the benefit of the players, that will not save them from being amenable to CCI's jurisdiction, because they are protecting commercial interests of these players. And as far as any body is protecting the commercial interest of its members, it will be amenable to CCI's jurisdiction. That is what happened in West Bengal Coordination Committee case also, because that coordination committee was protecting the interests of the artists who were engaged in commercial activity. So at present, CCI's take definitely, though it varies from case to case. However, as far as sports associations are concerned, if they are engaged in any sort of commercialization, which they largely are, because they perform the dual function of being a regulator and also organizing the events. Current take of CCI is that they are amenable to CCI jurisdiction because we have several cases ranging from BCCI's case to Shravan Yadav's case, where Volleyball Federation of India was also held to be an enterprise, including All India Chess Federation. That matter is currently closed. So that is the takes.
Very well put. Very well said. I think this is the balancing line, because we think from the perspective of an industry, the CCI thinks from a border perspective. And I think very well put, because you have been an integral part of CCI also. Well said. Abhishek Malhotra, founding and managing partner, TMT. Abhishek, fortunate to have you. Very well known in the TMT industry, technology, media industry. Many defenses, representations which have been made on this subject and other subject relating to DOT, TRI, etc. Also, Abhishek has been very well known in the fraternity, and because you also represent media industry, Abhishek, we thought that we should ask you on the present reality, ground reality situation. What, if any, are the competition law or the policy issues that are impacting sports broadcasting, which is much in the forefront now? Abhishek.
Thank you so much. Thank you, Lex Witness, and to SCLE for allowing me to participate in this wonderful discussion. And thank you, Zameer, for a more than kind introduction. I do not know whether all of that is deserved, but I will try to do justice to some bits of the language that you used to describe me. In relation to the space of sports broadcasting, whenever the debate has come up, whether it is in courts or it is at a policy domain, very often, because of the fact that there is a greater passion associated with sports, there is a greater amount of revenue potential that is associated with sports, and there is a nationalistic fervor that is also very often associated with this particular domain. Sports broadcasts have tended to be looked at slightly differently compared to the other broadcasting. Of course, there is a certain pedestal at which news broadcasting is looked at. But if you are to look at the non-news sphere, there will be general entertainment on the one end and sports being considered separately. In fact, it is in keeping with that distinction that when the TRAI was coming out with its new regulatory regime in 2017, just as a precursor to that, when they came out with the draft regulations in 2016, they had provided for sectoral or subject matter sort of caps depending on the kind of channel that was being broadcast. So for the first time, the TRAI was coming out with an MRP regime to say that, to tell the consuming public that this is the maximum that you will have to pay for watching a particular channel. And in that, the highest cap was put for sports. It was 19 rupees. When it was challenged in the Madras High Court, whereas the sector-specific caps were removed, however, the overall capping was still retained at 19. And that perhaps gave an indication of the fact that when I'm going to construe the entire bouquet of channels that are being looked at for the purposes of subscription, then I have to look at both the lower end of the spectrum and the higher. So lower, of course, always is a free-to-air channels, and some of them did convert to pay after this regime was implemented. But the highest chunk was given to in recognition to the investment perhaps that is made in the sports arena. Now, in terms of the competition law concerns, if one is to really go into that question, it's important to take one step back and try and find out as to what really, if at all, there are going to be any competition law concerns in light of the existing regulatory regime that applies to the broadcasting sector. Just some data points or figures that are important to know in this regard. If a consumer is to watch, so only two broadcasters in terms of companies in the country today control the entire pie of sports broadcasting in the country. That's the Star Group, Star Disney, and the Sony Pictures Network Group. Star, of course, has Star Sports and the subsets of that. And Sony had purchased 10 Sports, so they have Sony 6, 10 Sports, etc. Now, between these two, whereas they control the 100% of the sports broadcasting pie, however, has that led to a competition concern? To answer that question, you have to see how much it is that they are charging a viewer to actually watch sports content. If someone is to watch sports content through the year, you're not going to be selective about taking it, let's say, in the ongoing India-Australia series. By the way, we've fared very badly today this morning. But if you want to watch it only for this particular series, you have to pay X amount. You can also choose to take it for the entire course of the year or selective time period. Just as a data point, it's important to know that at the lower end of the spectrum, even if I am to subscribe to all the channels in an a la carte mode, I can choose that I want X, Y, Z, this sort of a channel. If I take all the channels, the maximum that I pay as a subscriber over the course of the year is 1,380 rupees, less than 1,500 rupees in the entire year. I pay 1,800 rupees in the entire year to subscribe to Times of India. That's the kind of distinction that we're talking about. So it's because of the fact that by regulation, the TRAI has imposed some sort of a cap, and that cap, mind you, is not that you can never price your channel above 19 rupees. That cap is because if I'm offering it a la carte, I can price it 100 rupees. But unless I price it at 19 rupees or lower, I can't put it in a bouquet. And that's how the consumer receives the channels in India today. They prefer to get an entire bouquet of channels rather than have to selectively go and choose individual channels on a daily or a weekly or a monthly or an annual basis. So if it becomes part of a bouquet, it becomes cheaper. For the as an overall perspective, I can watch news, I can watch current affairs, I can watch movies, I can watch general entertainment, and I can watch sports. So the debate in relation to competition and policy law concerns has to take into consideration that the real impact from a competition concern has already been addressed and taken care of by the TRAI, and the manner in which the dynamic of the business has actually worked. Not many people know this, but a broadcaster is prohibited by law, by the uplinking and downlinking license conditions, to offer the channel directly to the consumer. They have to give it to the delivery platform operator, who then acts as an intermediary and then takes it to the consumer. So there is that additional layer of protection there. The third aspect that is important to note in this is that there are other restrictions. For example, the mandatory sharing of sports broadcasting act. So its impact has been watered down by the Supreme Court to a certain extent to say that, look, you as Prasar Bharati have this legislation in place. You're doing it in public interest, and you're mandating that this is a sport of a national sort of importance, and then only then you are notifying that particular series or that particular event to be or necessarily offered to you as a clean feed for your network. But then don't kill the market for the broadcaster who's paid perhaps billions of dollars to acquire those exclusive rights. And therefore you restrict it only to your terrestrial networks and or to your free dish that is available for viewing by people. You can't use that to be put on a private cable network, because that would effectively destroy the market. Why would someone pay money, even if it is less than 1,500 rupees in a year, to watch a Sony or a Star Sports when they can get that same thing for free on the free-to-air network of the Doordarshan? So that's another, it was a limitation on the rights of the broadcasters, but that limitation was then balanced by the Supreme Court in this particular manner. The last bit of point for relevance with regard to competition policy, etc., is that at the end of the day, the increase or the importance of sports broadcasting in any sphere has always, it may not be in the same proportion, but has always led to a greater popularity of that sport and a more acceptability of that sport, and two, players getting some part of that money and therefore getting encouragement to come back to that sport and participate more in it and increase the overall quality that you're getting from the sport. So yes, a player doesn't come to play for the money, essentially. They come into play for the recognition, they come to play to display their skills. It is a platform for them to be able to provide that. But if, as a corollary, you are able to earn enough to sustain not only your interest in that, but also to take care of your needs, then why not? And that has actually been, to my mind, facilitated by virtue of the growth of sports broadcasting. So in all these respects, I think competition law concerns, if any, are adequately addressed by the the policy parameters and the regulatory environment that already exists.
I agree. And I think you put it very well. So yeah, we again come back to the discussion of free market. And I think in the free market, these arrangements are also counterbalancing themselves in the industry, while the regulator looks at it from a perspective also. But I think today the point what you have made is the chain of the things which are consequent to sports getting commercialized and being well known in the fraternity. And I think that's the chain we are talking about. Chain is very well managed. Opinions are taken. These agreements are also developed after opinions have been taken. They have been evaluated from a forefront, whether they are within the competition regime which is existing and they are not going overboard. So even corporates have been diligently following the same. And you have just shown that picture to us where the balancing act is coming and how the regulator should also look from that perspective. All right. So the next round of question is about 1 minute or max 1.5 minutes. Your single closing view on the questions which I will ask you so that the audience gets a glimpse of the thing. And then we have 5 minutes for the question answer sessions from the audience, what questions have come to our panel. Starting with Mr. Bhatia. Mr. Bhatia, I will also ask you in the end that there are 11 years which are completed after the Competition Commission of India has now been formed. But my opening question to you is, in the wake of recommendations of the Competition Law Review Committee, the government is contemplating to bring amendments in the Competition Act. What, according to you, is going to be the most important amendment in the Act? 1 minute. Most important one, which you think will be very critical. You're on mute, Mr. Bhatia.
In the proposed amendment bill, it is contemplated that Competition Commission will have power to settle the issue and also to accept the undertakings from the alleged delinquent parties. Right now, there is no mechanism, there is no provision for settlement of the dispute between the competition regulator and the alleged delinquent party. So with the result, Zameer, you may astonish that the Competition Commission over a period of 11 years has imposed over 14,000 crores penalty on delinquent companies and delinquent officers. But unfortunately, the recovery position is completely dismal. It has collected only 65 crore rupees. So,
is it so different?
Yes, so it is less than 1%. So I think going forward, Competition Commission will have settlement provisions once the amendment bill is approved, and this will to a large extent help the corporate sector as well as the Competition Commission to resolve the issues, and it will help in that we will have shorter duration of the inquiries before the Competition Commission. Another suggestion, I will only half minute I will take. I think a time has come. So the proposed amendment relating to settlement and commitment will not have retrospective effect. It will be only prospective in effect. So the Competition Commission should think of launching settlement schemes in respect of old cases, so that like income tax, etc., like company Ministry of Corporate Affairs, so like Vivad Se Vishwas scheme, like that should be launched, so that the 14,000 crore penalty which has been imposed, we are able to have a much better picture than what currently exists.
Very well said. I think these are some critical suggestions you have given. I think as an ex-regulator and one of the most experienced, seeing both sides of the regime of MRTP and CCI, I think this is one of the learned suggestions which is to be welcome to the government also. Very well put. Thank you very much, Mr. Bhatia. Pulin, sports agreement in sports industry is without doubt a very promising and beneficial investment for the parties involved. Simply put, it is an easiest way of commercialization of the sports. However, the legal issue that most fans miss out is the way in which these agreements restrict the trade. Is it important for us to identify if these sponsorship agreements are truly a pure mode of revenue generation, or is it a trade restraint and competition policy violation in disguise? 1 minute, your quick view on that.
Yeah, very quick. I would say that the sports has power to change lives. So basically, and to your particular question, I would say that it should not be looked at always from the umpiring point of view, because all the competitors, everything is given a bid opportunity. When you bid and succeed, then probably you should be given right to also expose yourself. So that's the way it should take place, and this is what I think it is happening. Sponsorships are invited from various sectors, various categories like airlines, hotel, and many other things. In one sporting event, there are many areas are there where you can always compete at the time of bidding, but after winning, there is no question of taking back the medal from him. So if I become a little bit emotional if it is talk of any sports industry, because the sports has gone into my blood now. So even I had to make it today also that I play at least some part of golf. So I played some golf, then rushed to pick up my laptop and then rush to a Wi-Fi network. But yes, all apart. The question to be answered in a way that I would say that all the screenings and rules of the game should be applied at the threshold, and beyond that there should not be any restrictions, because the huge amount of investment has been made and the commercial exploitation right should always remain. But yes, subject to rules and regulation. That is what my point.
Okay, so I think you are speaking on the lines of Facebook, when the Justice Department and there was a cases of anti-competitiveness which has been filed in United States against Facebook for breaking up Facebook Messenger and Instagram. The first defense Facebook has come and said to the regulator that you have only approved this deal and we have purchased these companies after your approval, and today you are saying that we are anti-competitive. So I think you are saying that it should be applied at the threshold itself, and it should not look as an after effect shocks.
Exactly.
All right. Satwik, we look antitrust. There is an interplay between antitrust and international trade policy. We don't have the so-called international antitrust law, and therefore some days you hear about Google in European Union, some days you hear about Facebook in anti-competitiveness in United States, you hear about India jurisdiction, etc. Can you tell us one important development which is happening at the international fora that warrants an understanding of this interplay, especially at a time where we don't have any international antitrust law?
So first of all, in order to understand the status quo, right, I'll want to go back a few years and say that at the WTO, World Trade Organization, there was a working group which was created back in 1997, immediately after the WTO was established, to study, to analyze the interaction between trade and competition policy. But that working group was dissolved in 2003, because it was realized that at that point of time there were barely just 50 countries which actually had competition law in the domestic law, and we realized that was way too premature to really look at an interplay between trade and competition. But having said that, right now we have around 135 countries which have a robust domestic competition law, including India, and now there've been a push to reintroduce competition when it comes to international trade. Now why is there a push? There are three things. Number one, we looked at market sharing agreements We've looked at revenue sharing agreements, technology transfer agreements, broadcasting agreements. These agreements, when they are between two entities from two different jurisdictions, these agreements, although they are commercial agreements, they would definitely be bound to greater extent with the commitments of the countries from which these companies come from. Suppose we have Sony Entertainment Network. If Sony is a Japan-based company, and they are bidding for broadcasting rights for IPL, for example, or for any other, for I-League for that matter, they will be the provisions would be bound by the commitments which India and Japan have taken, both under the WTO as well as under the FTA, which they have, the bilateral agreement which they have. Again, depending on if it's a broadcasting agreement which is being signed, then the broadcasting services will come into the picture. Another question is again, in services, there's something called domestic regulation. Countries can adopt certain regulations in the form of domestic regulations, and these regulations are licensing requirements and procedures and qualification requirements and procedures. Now, these both are very important elements when sports regulation and sports events organization takes place. We have, like, I keep on going back to cricket because we have BCCI system is pretty robust. We have list A, list B, list C candidates. Right. Now that is the qualification part. Maybe tomorrow BCCI.
So from an international perspective, you are saying that, if there is a commitment in the WTO or if there is a bilateral treaty or an FTA, I think those will also come into play while these foreign companies are bidding into it. Okay, an international perspective. I just want to ask this to Aahna. Aahna, we have just 1 minute per question. Basis the ruling in Mecca, Medina, do you endorse the idea of having exclusivity agreements in sports? And do you think that such agreements are restrictive in nature? Your views, closing views.
So I think we are all on the same page with regard to reasonable restraint is important for sport to thrive, right? So, I mean, today, to put in a completely practical perspective, there's Shah Rukh Khan, who owns a team in IPL and also owns a team in CPL. There's again Mohit Barman, who's gone ahead and done that, owns Kings 11 and just invested in a CPL team, which is the Caribbean Premier League. So to the extent that there's exclusivity in terms of territory, in India, they can't own another IPL team. That I think that's only fair. But the fact that they can invest in other cricket IPs is also giving them the space to expand their business, or for that matter, cricketing IPs. And there's a popular case that I'll just cover in a span of half a minute, which is the ENIC case in the Europe, which basically ENIC is a listed company on the London Stock Exchange, which had investments across 5 to 6 football clubs in Europe in different countries. So Italy, England, France, etc., etc. And basically there's a UEFA regulation which states that no club participating in UEFA club competition may either directly or indirectly hold or deal in the securities or shares of any other club, or for that matter, be a member of any other club. All right. So basically, if there is one company that owns stake in several clubs and you qualify to participate in UEFA, clubs of a common ownership, that only one such club can participate. So when ENIC filed a case, basically ENIC argued the fact that this was restrictive in nature. It restricted investment in sport. Whereas the fact is that once this rule came into place, ENIC went ahead and invested in other clubs. They actually increased their investments.
Oh, okay.
So what the EC held was that the fact that this does not disrupt competition, rather ensures protection of competition and integrity of sport, which therefore is necessary and proportionate in nature as a regulation, and therefore upheld the UEFA regulation. So reasonable restraint is great. I mean, but on the flip side, there's also been a case talking about ticketing. So it was about the French football World Cup in 99, when France was the host of the Football World Cup in 1998, when what they did was, when they were selling the first round of tickets, what the organizing committee did was they were selling a group of tickets. So there were tickets being sold for about 5 to 6 matches. You didn't know which 5 matches you were getting to watch. And the prerequisite to be able to buy those tickets was that you had to have a mailing address in France to be able to buy those tickets. So I should be able to courier you the tickets in if you had a French address. So in this case, the OC's reasoning for this was that they wanted equal amount of representation in terms of spectators for all teams. Rather than naturally, if I'm a French citizen, I might want to buy tickets only for the French national team competing, right? Which is what technically happens in India. I mean, largely you see the kind of audience when the Cricket World Cup is hosted in India games versus other games. So to ensure this, but this sort of was held, this exclusivity in terms of selling only to French citizens and not making the tickets available to people at large, even in the first round, was held to be restrictive in nature and unfair, which basically imposed trading conditions on, restricted trading conditions on people outside of France who want to buy those tickets. So again, coming back to the point that reasonable restrictions are great. Some amount of exclusivity, of course, is required basis territory, but it cannot be one size fits all approach. So while you can own teams in different territories, but yes, tickets should be available to people of all territories.
I just want to bring to my attention of my speakers, we have got a request to extend this session because the audience is really enjoying this. But yeah, the speakers also have a commitment. We'll take all the questions. We assure you that we have multiple questions coming up, but that's a compliment to the speakers also that such request has come. While speaking on Aahna's point, Niti, she gave one part of the perspective. Has the player restraint policy of league sports led to a monopoly where you have a single buyer but many sellers? Powers of the team owners. Has the player restraint policy of league sports led to exercise of monopoly powers of the team owners? And has it affected the recreational characteristics of the sports? And if so, what is the take of CCI on such agreements? 1 minute.
Yes, sir. As far as team owners are considered, they definitely have better bargaining power compared to the team players. However, the monopolistic power has not reached the magnitude as it existed in Hockey India's case, because there it was the sole buyer and organizer of the events, and it was considered to be a dominant player in the market of service of hockey players. In league sports, we have multiple team owners, and in relation to the players, definitely the team owners are at an advantage. And CCI so far has dealt with such a case in Hockey India's case, where there was Hockey India being the only sole monopolistic player in the relevant market of service of hockey players. However, there is we still need to see what CCI's concrete take will be in case of team owners specifically, who will be private entities and not a national sport regulator.
Okay. Abhishek, from a media perspective, in your view, is legislation actually prohibiting ambush marketing defensible from a competition impact analysis point of view?
So at the end of the day, the heart of the debate is really this. Ambush marketing is commercial speech. Commercial speech is protectable under 19(1)(a) of the Constitution. When it comes in the form of, let's say, a legislation, first of all, we don't have a legislation currently in India that prohibits ambush marketing. And therefore, the attempt of the ICC to restrain marketing or ads that were akin to ambush marketing in 2003 were not permitted by the Delhi High Court. Delhi High Court said that this is commercial company jargon, but it does not find place in the law. And because it does not find place in the law, therefore I'm not going to restrict it. There are various countries of the world that, in relation to either the Olympics or any other, let's say the FIFA World Cup, have made it a requirement for the hosting country to put in place a legislation that actually bans ambush marketing. Now, of course, it depends at the end of the day on specific legislation as to what are the contours of such ban. But stricto sensu, as long as you are not using the registered trademarks, as long as you're not using protectable property, as long as you're not using or you're not engaging in conduct that is in violation of the existing codes in relation to advertising of that particular country, then to that extent you will be sort of safe. And then the legislation, when you're looking at it from the point of view of a competition impact analysis, would then be brought into question as to whether this is permissible or not. So I think it would depend upon the language of the legislation and the extent and the reach of what it is trying to prohibit, and what exactly it is that it is actually playing out in the domain. Because today, if I am being restricted from exercising my, at least in India, my fundamental right, then how is that going to be viewed with regard to a competition analysis? Am I not being allowed to, let's say, compete for the FCT time on a broadcast of a particular event? So those issues, I mean, they've not reached, to my mind, the competition regulator yet, but this is one food for thought, for one aspect that could perhaps come up for consideration as and when we do have a legislation.
I agree with you. I mean, it's not come up yet, but it's a fundamental right to do business. And this would come up at some point of time with the CCI. Very well said. And I think futuristically, you always do that. Maybe you're predicting certain issues in future, which would definitely come up and see the test of time. Mr. Bhatia, just as an ex-regulator, ex-Director General of Competition Commission of India, CCI has now completed 11 years of enforcement journey. As a practitioner of competition law, what is your experience and what is your message for corporate entities and their directors and officers? A general message to the industry, how we balance both sides of the coin, so that we do free market, we talk about free market, we do businesses, we have business growths, we have competitive business at par with some US names we are citing, but we are creating here also in India, and do balance it from a competition perspective so that we don't have a regulator also visiting us or questioning us. 11 years of experience and message to the industry. Mr. Bhatia.
Yeah, as I see, I think message is very loud and clear that business houses as well as officers must ensure that they are on the right side of law. And for that, it is inevitable that they should focus on establishing competition compliance program within the organization. Because the cost involved on compliance program is minuscule, qua the penalties which are imposed. And let me tell you that it is a global experience that it is said that smoking is injurious to health, but violation of competition law or antitrust law is injurious to your wealth. Because up to 10% of the turnover or 3 times of the profits, penalty can be imposed. And not only that, if you happen to be a delinquent director or officer, from your salary, a penalty up to 10% can be imposed penalty if you are found to be a part of contributed to the violation. So wisdom suggests that you should focus within your organization on establishing compliance program so that you are not found to be deficient so far as competition law is concerned.
So well put, sir. I think this is a great suggestion. I think the industry has to adopt that. Why I could link this is that I was having a chat with foreign law firms, and they said for GDR compliance, you don't have a checklist, you have a GDR compliance program. I think one should have competition law compliance program. I think once it becomes compliance part of it, then you evaluate. What a great suggestion you have given, sir. I mean, you're one of the stalwarts of the industry. We really respect and salute you. We had a great panel, Mr. Bhatia, Mr. Abhishek Malhotra, Mr. Pulin, Kumar, Ms. Niti, Richhariya, Mr. Satwik Shaker, Ms. Aahna, Mehrotra. I think we are really grateful. Great insights you have given about the antitrust in sports from a competition law perspective. Good suggestion, good recommendations, good interpretations of the law. There are a few questions which we would take up. Any of my panel members are free. We would answer these questions in 30 seconds. First question is to Aahna. Aahna, do you think that a competition act lacks provision pertaining to the restraining agreements despite of section 3 and 4 of the act? Are we in need of adoption of regulatory guidelines for sports industry from EU antitrust policy? 30 seconds.
And I don't think our act really lacks it. It's just a matter of interpretation. And you see that in a sporting context, there is this peculiar position that we're on, that there is a court of arbitration for sports, right? And that is the jurisprudence also that we must take into consideration. So it's just at the end of the day a matter of interpretation in terms of whether you take the cash judgments or the specific current rulings that exist as far as the Competition Commission of India is concerned, and apply it to the sports sector.
Okay, so it's a point of interpretation. Mr. Pulin Kumar, the question is, agreed that commercialization of sports is important and sponsorship is one of the most promising way to do. But the question is the channelization of these bids, avoiding the bid ringing. Are these sponsors foreclosing market for others?
Channelization, I didn't quite understand the terminology as to how it is avoiding bid rigging or foreclosing the market. But whatever I understand, I would attempt to answer your question.
Right, sir.
See, I would say that again, there's no kind of foreclosure in my view, and to what extent we have participated as in a sports industry in the any of the bids. I haven't seen any bid rigging because we are aware of the law, and bid rigging is of course is not allowed, whether it is in terms of any law and anything. So we are quite aware of, for that matter, anybody who participates into the bid, that is one way of kind of having a free and fair kind of assessment, and also bidding and giving opportunity to everybody. If you look at the I'll just give you some simple example of that. You have a government portal from the sports ministry as well, that is called GEM, where you can list your products, you can advertise your product, you can sell it, and it's free for everybody. So therefore, I don't think that it is going to foreclose any of the competitors, and it's rather promote the competition as far as the potentials of the sports industries are concerned. They will be well exploited in submitting the bids, and that's a way to go ahead, I think.
Okay.
According to me, it's not a foreclosure. Thank you.
Yeah, I think the companies are quite due diligent in approaching this. Maybe news media reports, other things are otherwise. But point is that there are certain checks and balances input. We want to assure all the audiences that we are going to answer all the questions. We have extended this session for you. And whatever questions you have, you can put in the question answer box. We will answer all those things. We have taken permission of our learned speakers for additional 10 minutes, and we will go ahead with that.
I think to the answer that the producer just gave, and that segues a little bit into, and of course it's not in the same context because the question is more in relation to bid rigging and foreclosure of the market for the others. But that's where the other aspect of what I answered in my second question of ambush marketing comes in. I mean, it's been labeled as ambush marketing, and there is a particular reason for it because it's considered in that particular light. But the market is not foreclosed, and at least to the extent that A, there is no legislation that categorically bars it, and B, even if there is such a legislation, there will always be creative workarounds which are not illegal, but nevertheless, I don't think in my submission they would foreclose the market.
Right, I agree with you. I think your second question, you're right, was on that perspective. It looks like, but I mean, the companies are not. It's not a foreclosure otherwise. Satwik, international perspective, agreements can be written or implied. Taking the cases of cartelization in India, CCI has time again ruled that the conduct in itself is treated as implied agreement. Then why in HI case, CCI negated the presence of anti-competitive agreements? You can just share your views. You can have an interpretation of your own.
Yeah, very quickly. There could be two ways of approaching this question. One is obviously through implied agreements by manner of conduct, and another is through looking at the bylaws and the constitutions of the sports regulating body, as the CCI did in the All India Chess Federation case, because in All India Chess Federation case, the federations wanted to restrict participation by players into unauthorized tournaments. Now that was challenged, and CCI looked into the matter, looked into the bylaws and the constitution of the All India Chess Federation, and said that because there is no definition of unauthorized tournaments within the bylaws, then it's not just about the conduct, what you do. It's also about what you actually write in your bylaws and the constitution. And if it's not defined there, if these aspects are not covered in your bylaws and your constitution, it means that you're going beyond the scope of your functions and your powers. So there could be both the ways. And yes, CCI could look at it from both the conduct point of view as well as from the text of the bylaws and the constitution point of view as well.
Right. There are 2-3 more questions. We will take it up before we close the innings of the day. I have one question which says Indian football is on the road to merger between its two main leagues, ISL and I-League. Certain small clubs of I-League were apprehensive of such merger because of the increase in the competition in comparison to the funds they have to buy players to survive that competition. I wanted to know if a free market should prevail in terms of competition in Indian football. Anybody can take it up. Aahna, you want to go for it?
Yeah, sure. So, I mean, again, you have to look at it from a global perspective, that the global football market is anyways functioning on this relegation and promotion system. You can't really break away from it. And if I was to put it in a practical sense, you look at Rajasthan Royals, right, which started as the underdogs in 2008, but went ahead to win the first edition of the IPL, even though they had, I mean, the least amount of star players, so to speak. And again, putting it in a football context, in 2018, I think it was the first time in about 50, 60 odd years where Italy didn't get a chance to participate in the Football World Cup, even though they have the credentials. So at the end of the day, you're also talking about quality play as your top division league or your, sort of premier tournament in the country. So if a team has the caliber, and I don't think financial sort of ability is the only hallmark to judge in terms of quality play, you can still get some star players who might be labeled as underdogs to, go ahead and win a tournament. So from that perspective, I think what they've gone ahead and done, the AFC having pushed this whole relegation promotion system starting 2024 season, and the inclusion of I-League clubs in, and going ahead with that whole first tier, second tier of leagues in football leagues in India, makes absolute sense from a global perspective.
Thank you so much. I want to really thank all the audiences. We are getting your questions. We are getting your request to extend. We will just ask one final question, and then you can tie up with all of us on LinkedIn. We'll be really happy to connect with you and answer all the questions. Final question, Mr. Bhatia. Has CCI deviated from the actual concept of cross elasticity while determining the point of relevant market? Reference BCCI case and Formula One controversy as discussed in Cellophone case. If you can throw some light on it.
I think my answer will be relevant market is the most complex and highly debatable issue worldwide in competition literature. You see, as a defendant counsel, I will always endeavor to broaden the market, and as a prosecutor, CCI side, they will try to narrow down the market so that it can be established that you are dominant in the relevant market. I think since BCCI matter, sir, is an appeal, it will be very difficult for me to give any kind of opinion whether CCI did a right thing or a wrong thing. So kindly excuse me for that.
Absolutely.
But certainly, relevant market is the most debatable and complex issue.
Absolutely.
So you are not ruling out the possibility of third umpire everywhere, no matter where I am.
Yeah, third umpire to give the right decision whether the ball is within the line or outside the line, I think. Yeah. All right, but it's a privilege. Thank you so much to the audience. Your response has been tremendous. We are really privileged. Thank you. We have extended beyond the time just for you. I really want to thank Mr. J.R. Bhatia, Mr. Pulin Kumar, Mr. Abhishek Malhotra, Mr. Satwik Shaker, Ms. Aahna Mehrotra, and Ms. Niti Richhariya for your wonderful views, interpretation, case studies, examples. lot of inputs, a lot of questions answered. Really good forum, and therefore we could extend the time on the wish list of the audience. You can connect with all of us on LinkedIn. I want to also thank Lex Witness for organizing this wonderful event. The subject was itself so nice that we had this engaging audience with us. And I want to thank Society of Corporate Legal Experts. Thank you everyone once again, and see you soon. Thank you.
Thank you so much.
Thank you.
In addition to what
you.
Mr. Nathani has already said, I extend my gratitude towards all the esteemed panelists and Mr. Nathani in itself, and the organizing teams, Lex Witness and Society of Corporate Legal Experts, for such an enlightening session, and all the attendees for asking such intriguing questions. Thank you again.
Thank you.
Thank you, everyone. Bye-bye.
Thank you so much, everybody. Zameer sir, seeking your permission to end the webinar now for everybody.
Right, sir. Thank you very much,
Thank you so
everyone,
much.
once again.
Thank you very much.
Bye.
Thank you.
Thank you.